dia a todos e todas. Vamos começar então mais uma live do Legal Ground sobre concorrência em plataformas digitais. Hoje nós temos o prazer e a honra de receber o professor Christopher Yeo, da Universidade da Pensilvânia, que vai abordar também como o tema é tratado não só na Europa e nos Estados Unidos, mas, por outro lado, limitações da regulação ex-ante nesse mercado. Eu vou, então, mudar para o inglês para dar as boas-vindas para o nosso convidado. E então a gente começa com uma apresentação e depois abrimos para os debates, lembrando que todos podem encaminhar questões ou comentários para que a gente possa trazer e passá-los ao nosso convidado. Então, vou mudar para o inglês. I'm going to switch to English now. Professor Christopher, it's really an honor to have you here with us today. And we are anxious to hear your enlightening considerations about competition in digital markets. I'm going to ask Bianca to make a proper presentation of you, and then we start with your presentation.
Good morning, everybody. It's a great pleasure having with us today Professor Christopher Yeo. Professor Christopher Yeo is the Imassogie Professor in Law and Technology, Professor of Communication, Professor of Computer and Information Science, and also founding director of the Center for Technology, Innovation, and Competition in the University of Pennsylvania. All over the world, there's a movement to shift antitrust conduct analysis in digital markets from an ex-post approach to an ex-ante regulation. In Europe, it is reflected in the Digital Markets Act that has already come into force. In the US, the American Innovation Choice Online Act is still under appreciation of the US Congress. And in Brazil, we have the Bill 2768 from 2022. We will discuss what is the impact of legislation such as DMA on innovation and SMEs. Imposing restrictions on platforms may lead to trade-offs between competition and innovation. When it would be advisable to use ex-ante regulation? Is DMA a return to structuralism? Are these legislations part of a return to a populist approach to antitrust enforcement? And if we think, will this approach lead to over-enforcement or misdirected enforcement, which might stifle innovation and harm the competitive process rather than protecting it? We will discuss most of these questions today with our guest. The floor is yours, Professor Christopher.
Well, thank you very much for such a generous welcome, and thank you for inviting me to join you. If it's okay, I will share some slides that I prepared to help move our conversation along. So, among other things, this is an area of great interest around the globe. It's of interest to me personally as well. I'm in the process of working on an edited volume forthcoming in Cambridge University Press, specifically studying the impact of the DMA and how it is moving forward, and do analysis and give frameworks to evaluate it. I would like to share with you initially some early experiences under the DMA, how it is playing out, because it has just now gone into force. And we now are learning from some of the early aspects of it that not at a point where we can study it academically, but more or less we can begin to see some of the impacts. Second, I'd like to talk about frameworks for thinking about ex-ante regulation more generally, figuring out, because to me the question, no approach is always the right approach. You always need some sort of framework to understand when to use different tools. And I think that there's some interesting frameworks that come out of legal scholarship. And then lastly, I would like to talk about this, the specific ex-ante framework reflected in the DMA style approach. And then I'll briefly talk about what other countries are doing, just to give it, to try to put it in a broader international perspective. So starting first on the early experiences under the DMA, one of the most surprising unintended consequences, it has had a relatively negative impact on hotels, restaurants, airlines, and local merchants. Why? Hotels report that traffic to their sites, their direct websites, have dropped 30%, and direct bookings on their websites have dropped 36%. And realize what is happening is because of the changes required by the DMA in terms of search results, A lot of the traffic that used to go directly to the hotels is going to Booking.com, Expedia, and other online intermediaries. And this is a problem for the hotels because they have to pay a commission for them, and they're now generating less revenue for the same amounts. And this is a good source of great concern. In fact, what you see is trade associations from the travel industry across Europe are raising concerns. Politicians like the French Senate and hotel CEOs have raised the flag, saying that this aspect of it's a strange aspect of the DMA. It doesn't prevent intermediaries. It only prevents intermediaries above a certain size. And what's happening is it's having the unintended consequence of giving preferential treatment that was previously unavailable before to intermediaries who are not quite large enough to be the designated platforms under the DMA. So this is one of the impacts we're seeing right away. The other one is happening on innovation. And the other interesting thing is the effect is happening on innovations that are occurring in the market, but also innovations that haven't yet occurred. So if you remember when Google first launched, it used to just give you results on a sheet with links, and you clicked on them, the advertising links at the top, and some of the others, and then the rest of the results on the bottom. In recent years, Google has pretty radically changed its research results. So this is an example for Hotel Madrid, and you see not only the links, but you see a map, so you can figure out where they are. You see price information represented here, and you can see drop-downs below where it says Hotels Madrid, Spain, where you can specify the dates you want to stay, the number of people, ratings, budget options, so forth, cancellation policies, so you can target just on the search page to get results of what you're looking for. Now, what's the problem? What's interesting is this requires an integration with Google Maps. Theoretically, you could try to do it with a general mapping function, but to do that, you'd have to create some sort of interface and open APIs, and then which one do you use, and they vary in terms of quality. You also need to have some functional connection with some travel site to give you the dates and the different reservations. And so if you want to see, this is what Google search looks like if you do it in Brazil. It's what Google search looks like if you do it in the US. It's what Google search used to look like when you did it in Europe. But now it looks like, once again, like it did before, just links. Because the vertical integration, the non-self-preferencing requirements of the DMA is forcing them to roll back innovations they used to put on there that they didn't do before. And so this is a drawback we're seeing in current innovation. Now, what's also interesting is in terms of future innovation, the requirements of interoperability and non-self-preferencing and have caused a number of delays of new innovations from deploying in the European market. So, for example, when Meta launched its new product called Threads, which is a competitor to then Twitter, now X, when Twitter sort of began its spiral downwards, it had to be delayed by 8 months because they couldn't actually make it compatible. Much more concern is the AI properties. Microsoft Copilot and Apple AI have not deployed. And it looks like they're not going to for an extended period of time because they cannot actually comply because they use so much proprietary information in generating it, and there's different problems. It's causing compliance issues that is delaying innovation from rolling out in Europe. We see quotations from a number of European entrepreneurs who have successfully launched businesses who say they're staying away and they're not going to continue to do it. One entrepreneur in a slightly different space, he gave me a quote which has always stuck with me. He said, "Entrepreneurs are dreamers. And if you make it and you hire a bunch of lawyers before I have to dream, I will still dream, I'll just do it someplace else." And so it's an interesting mindset that entrepreneurs have, and it's to me it's an example of how we've known since the 70s and the 80s that informed regulation is sort of a form of taxation. It just makes the cost of doing business slightly more expensive. And like any form of cost you're adding to a business model, you're going to lose on the margin some innovations that would otherwise normally have happened, and they won't because they find the compliance too difficult, and the more heavy the compliance cost, the bigger that loss is going to be. And what's interesting is there's a wonderful quote by the Ericsson CEO. Now, Ericsson is a equipment company he's not directly doing a platform business, but obviously his business depends on people using the internet more heavily and upgrading what they need. And he's very concerned about the implications. He says Europe may turn into a museum. That is a place where old things are, because he's worried that new technologies won't roll out in Europe anymore. And so this is a real concern that many people in Europe have, and the early returns are showing some unintended consequences in terms of who benefits and who doesn't benefit, but also some negative impacts on innovation, both existing innovation and new innovations that are preparing to roll into the market. So that's what the early returns on the DMA. Let's talk more conceptually about ex-ante regulation, and particularly the form of ex-ante regulation reflected in the DMA. So what I really enjoy looking for frameworks, because as an academic, you shouldn't just all propositions should be falsifiable and testable, which is and to me every policy has to have its limits. There's no one thing that's always the right thing to do. Usually, policy interventions, particularly in complex spaces, have to be fit for purpose. And so we need some conceptual idea. And in this case, the question is, when is ex-ante regulation the right approach? And when the alternative is usually ex post, case by case, the right approach? And we actually have some interesting frameworks from competition law and more generally from legal scholarship. Competition law draws a distinction between what we call per se illegality and the rule of reason. Per se illegality essentially being a form of ex-ante regulation because you formulate the rules and prohibit them in advance. Rule of reason is ex post, case by case. You look at the facts and in the totality of the circumstances, you evaluate the effect. There's also a debate in law between what we call rules and standards. Rules is drive 100 kilometers no faster than 100 kilometers per hour. A standard would be something like drive safely in light of all the circumstances. And in fact, you have different approaches. And both literatures yield a fairly rich and fairly interesting framework for evaluating when you do ex-ante rules. So one is you have to know your subject matter really, really well. So one of the natures of rules is they draw lines that on some level are arbitrary. The classic teaching example I give my students is in the US, the law says you can vote at the age of 18. And somewhere out there, there's a child who's 17 years old in 364 days and says, what's the difference between me and this person who's born one day later? He can vote, I cannot. Well, the answer is there's no real difference between the two. But rules, by their nature, draw these kinds of lines. That's what they have to do, and divide people into one group or the other. And if you're going to do that well, you have to understand the subject matter very clearly, and you have to have a great deal of experience. And in fact, that's become one of the ideas. Second is, even if you have a lot of experience, you have to be able to really draw lines that are effective and divide people into two different groups. So one is we reserve these kinds of lines for when we can clearly see there's certain kinds of practices that are nearly always harmful, so that if we prohibit them altogether, we don't lose very much. If it's an ambiguous practice, if it's sometimes good or sometimes bad, it tends to be a very bad candidate for ex-ante rules. In addition, the subject matter has to be homogeneous, because if it's extremely varied, the ability to draw those rules without having tons and tons of exceptions come in becomes virtually impossible. And then the environment has to be relatively stable. If there's an internal innovation environment, there's an external economic environment, if they're both changing very quickly, your rules will become obsolete very quickly. And in fact, what you see is in certain areas, they're very reluctant in particularly new innovations, but in areas, even fairly well-established areas, as we know, like, for example, accident law, tort law is still governed by a negligence standard, which is classic ex post, and it's not because we don't understand car accidents. Now, we do have little islands of rule-like principles that emerge, as we know. So if someone hits you from behind, the person who hit you from behind is almost certainly liable. So you have a general framework of case by case, but we have an understanding that in that situation, we can attribute liability in ways that are relatively simple. And so then the question is, this suggests a framework of how do we think about when we do ex-ante rules. And so what strikes me is, when I think about this in terms of the digital context, many people in Brazil have been concerned that there haven't, unlike in the US and the EU, there have not been a lot of enforcement cases. The officials' knowledge of the experiences of these technologies is very difficult. We're learning to restaff the agencies with data scientists and different technologists and even psychologists to actually understand how this goes. But in addition, what we're seeing is a really dynamic, non-homogeneous space where we're seeing ambiguous practices which are often great sources of innovation. Put a different way, most of the DMA is concerned about vertical integration, like non-self-preferencing, data sharing and the like. We're actually not trying to create more competition in the platform. We're sort of resigned to that being a large body. What we're attempting to do is to create entry by complementary services and to open up a vertically integrated stack to more competition. Now, what we know from the last 50 years of economics is that that's the one area where we used to treat the practices as per se illegal. They've all moved to the rule of reason because economic theory tells us that vertical integration is ambiguous. It's often beneficial to consumers as well as harmful. And the empirical evidence tends to suggest that it is much more often beneficial or neutral and extremely rarely harmful to consumers. And so we've changed with respect to vertical integration, a move from relative hostility to a more flexible, open-ended, non-rule-based approach. And if that's something that tells us this, is there a reason we think that the conduct prohibited by the DMA is likely harmful? Most of economic theory and the empirical evidence suggests that no, that's an incorrect conclusion. So in general, this framework to me suggests that this is the platforms are a relatively poor candidate for ex-ante regulation. Now, the particular kind of ex-ante regulation in the DMA is, as Bianca mentioned, is basically structuralism, it's structured conduct performance. Why? The DMA bases its liability on users, revenue, market cap. And it's not based on a relative size, it's absolute size. So it's funny, it's normally we think about dominance in terms of percentage of it. If it's a certain number of users, we don't even know how many the global users are. It's very hard to assess that. But it's also strange to me, it's a uniform set of thresholds for all platforms. The idea that the same relevant threshold will be the same for e-commerce and search and social media seems really unlikely. But really what we're seeing is the structured conduct performance paradigm is what we used to do in the 50s and 60s and is almost now universally rejected. There are many proposals in the US to bring it back. They've all been rejected. Part of the reason it's been rejected at the beginning is because there was awareness that scale economies are now were more important than people thought. And I would say now in digital economies, scale economies are even more important than they were in the 60s and the 70s when we did the initial rethink. But most importantly, what we've realized is that size is a bad indicator of performance. We know from contestable markets that large size doesn't necessarily mean bad market performance. We know from Stackelberg price leadership that small size isn't necessarily indicative of good performance. But the biggest issue is that large size can be the result of successful competition on the merits as well as anti-competitive activity. And so you see, in the kind of behavior where you see someone who solves impossible problems, they do very, very well. And in fact, that is the incentive. That's what we need to do. And the problem is that if you then turn on them because they're too successful at competing, you're going to lose innovation and you're going to lose benefits to consumers. The famous line from Alcoa, the successful competitor having been invited to compete must not be turned upon if it wins. Because otherwise, you can see the calculus, I'm going to do an investment and an innovation, and here's my potential returns. But if I'm too successful, I have to reduce the returns, my expected returns, by the antitrust liability. And in that case, on the margin, my net expected returns in the face of uncertainty go down. And the chance of me innovating on the margin go down as well. So they realize this. And that is the fundamental reason the US law has consistently rejected returning to structured conduct performance. I mean, think about it. And also based on the whole notion of structured conduct performance is that performance is what we care about, but it's too hard to measure. So they said, let's have a theory. Certain structures inevitably lead to certain types of conduct, and that conduct inevitably leads to bad performance. And what we said, in that case, all we have to know is structure. We don't even have to pay attention to conduct. And we took structured conduct performance makes conduct irrelevant. Well, there's a couple problems with this now. Our ability empirically to measure performance directly has vastly improved. But second is we think conduct is important. If we know that size can either be anti-competitive or a reflection of competition on the merits, we need some legal element to separate the good cases from the bad cases. And historically, that has been conduct. We've insisted on some sort of anti-competitive exclusionary conduct of leveraging or maintaining monopoly returns in addition to size. Size has never been enough. The problem with the DMA is it eliminates that requirement and returns to the notion of just size being enough for liability. And that is, to me, you can do it. You just have to explain why all the reasons that we asserted for abandoning the structured conduct performance paradigm 50 years ago don't matter anymore. And if they don't have an answer to that, then we should think about whether we really want to go back on whether 50 to 60 years of history of learning in terms of what we've learned of competition law. Lastly, the last point I'll make substantively is I've heard in a lot of countries where I've talked to that some people think the DMA is really the only approach. There's actually a lot of other approaches. I mean, for example, Germany, under the leadership of people who were the original people asked by Margaret Vestager, who wrote the report, Heike Schweitzer, Jacques Kremer, and Yves Montois, they're doing something along the lines of what was called the new competition tool, which stays within the competition law paradigm. They changed the burdens of proof and presumptions a little bit, but it's still basically ex post case by case. Japan did a market study. They've rejected the DMA for all platforms except for mobile operating systems, and they have a statute there, so they've decided to do a much more limited intervention. The UK has rejected ex-ante regulation generally in terms of individual firm level codes of conduct, so on an ex post case by case basis. I like the fact that it's ex post and better tailored. I'm a little bit uncomfortable with firm specific interventions because you're really depending on the quality of your regulator not to abuse that, to penalize certain individuals, and it can create, if they're not also, even without intending, they become first firm specific instead of sector specific, so you hurt certain firms and other people don't have to bear the same burdens even though they're doing the same thing. Korea's rejected legislation, although there are new proposals to do it because the parliament, their legislature changed hands. The U.S., you mentioned the ICOA, Bianca. Right now, ICOA is dead in the U.S. You know, people don't often appreciate this. It had a small chance in the last Congress, but even then, the California delegation was opposed to it, and it's not entirely clear they could do it. The current Congress has no interest in doing it. Obviously, we're doing another election. You never know, but I would say that there's a lot of opposition to it, and many people don't think it's the right thing to do. And right now, it's not just them. Australia, India, Thailand, a number of other countries, too long to mention, are trying to consider what to do. As of right now, only one country has followed the DMA, and that is Uzbekistan. And so the question is, you know, in terms of models, there seem to be a lot that are out there. So bottom line is, I'd say with your takeaways, I actually think the DMA can harm innovation in the early competition and can hurt consumers because of the way it's implemented. We know that from the early experience. We have frameworks for ex-ante regulation. You can make your own assessment. My assessment is that for something that's new and fast changing and this sort of thing, we generally don't do ex-ante regulation. I do think the structuralism is problematic, and hostility towards vertical integration goes against 60 years of what we've learned and is reflected in modern law. And in fact, there's a concern with the thresholds, it'll create sort of secondary distortions that people will limit their growth to avoid it or divide their companies or different things to try to avoid it, even when that might be good. And then lastly, DMA is one of many approaches. I'll give you the quote here from the OECD competition chair, Frédéric Génie. He thinks that ex-ante regulation in the space is anti-economic and anti-competitive. And he really has great concerns that will hurt consumers and innovation. And so I think that if I'm thinking about Brazil, I think that you have a great opportunity here to watch how the DMA plays out for at least a little while and to study other approaches and find out what makes sense for Brazil and find out what makes sense in general. But even Brazil, I will say, the DMA was the product of some very unique politics to Europe. In fact, were working on a different approach and under lobbying from Orange and Axel Springer, changed course in 2 weeks to what became the DMA. That's not something that's likely to generalize to many other countries, and I would look very closely at them to try to figure out what makes sense for an environment. For example, Brazil has some unicorns. It has a much more better innovative environment than Europe does. I think there's a lot going on that's very exciting here in Brazil that, frankly, Europe wishes they had. And that, in fact, I think that this is a great opportunity for Europe to step back briefly, for Brazil to step back, evaluate the full range of possibilities, and decide what makes the most sense for your country. So thank you very much.
Thank you very much, Christopher, for your intervention and contribution. There are some questions from the audience and questions that I'm sure Bianca and Cesar have. I also have some questions, and I'll try to join some of them. One of them is related to your criticism on the impacts of the early impacts of DMA on innovation. When you show, as I see, which regards, well, instead of avoiding the innovation that were tried, instead of big techs avoiding innovation, why then do not open the same possibility to competitors? For instance, instead of stop integrating the Google Maps, why do not open to other companies that have this service? this criticism. I would like to hear from Mo how to approach this criticism instead of assuming that there is actually an impact on restricting innovation. Is it not a reaction that is also not open to competition? This is the first one. I will let the other one, because it's related to another subject, for after you have commented on that.
So thank you for the question. It actually, I love this because one of the things about the reason I'm doing the book that I'm doing it for Cambridge University Press is because many people in the debate analogize the DMA to telecommunications regulation. But the debate pretty much ignores the history of telecommunication and the scholarship looking at it. What we've learned from the history of telecommunications regulation is we have tried to open up as much of the market to competition by complementers. So we used to think the entire telecom network was one natural monopoly. And then we discovered that equipment and long distance was competitive. And so we essentially did open access mandates and did the kind of solution that the question suggests, and that's reflected in the DMA. But here's the problem. We learned that there's certain places you can't do that. In other words, we kept reducing the size to it was just the local telephone facility. But at that point, the only thing about the local telephone facility that was a natural monopoly tended to be the copper lines connecting the office to the home. Like the switch became competitive. It used to be a big building, cost hundreds of thousands of dollars. Now it's a size of a PC and sits in a rack. It costs less than $50, maybe even less, $1,000. It's very easy to do. And that became competitive, but then you can't keep chopping up a firm smaller and smaller. What we learned is there's certain parts that interact with each other in ways that are too closely related that third-party provision really isn't a great option. And that, in fact, what we're seeing in this is, so theoretically, we can see about mandating interoperability. The whole notion of unbundling is that we can mandate interoperability anywhere. We've learned that certain things, it just doesn't work. And that, in fact, you see that part of it's the physical interconnection, but part of it's also the data structure. So one of the things that's interesting to me, one of the mandates of the DMA is data portability. Google and Facebook provide data portability now. The problem is every different system has its own data configuration. So even if you move it over, it's like trying to put the square peg in the round hole. The problem is, so the only alternative would be is to standardize the configuration of data. One, that's extremely expensive. Two, you pick winners and losers based on the configuration you chose. But three, the configuration of the data determines the functionality of what you can do with it. And so you have a risk of actually limiting the innovation and locking into a place an interface that everyone has to do, and at a time where we really don't understand exactly how all of this is going to work. And so what I find is this notion of, let's just open up Google Maps. Google could just do that for every mapping system there is. Well, we have, Waze, we have Apple Maps, we have Bing Maps. They all operate in different ways. And in fact, we have concerns about the quality of the information and all this. There's many different aspects to this we have to vet our way through. And that we learned from a vertical integration standpoint that there are certain things that are more efficiently combined in a single firm. So at the risk of being too academic about this, the origins of all this internet regulation in the US comes from a series of initiatives in the 70s, 80s, and 90s called the computer inquiries. And the computer inquiries we're going to first time combine computing with phone lines. And it became the modern web, which is we now have, servers and different things. It's not just voice anymore. And the vision of the computer inquiries was that all of those other services will be provided by third-party companies. And what we discovered is we lost billions in consumer welfare because there are certain things that are more efficiently provided by the network itself. To give you a very easy idea, there's a technology, I don't know how it's going to be as familiar in the terminology, in the English term is caller ID. It's, when you look at a phone, you see who is calling. I found this phone call is from Juliano or Bianca and your phone number, and I know who it is. The original vision of the computer inquiries is this would be provided by a third-party company. The switch, which is now a baby computer, already has all the information to provide caller ID. They keep track of who's calling for billing. So the cheapest and easiest way is to provide this service on an integrated basis. And in fact, we saw a number of services delayed and rolled out because the insistence that it be done on an open platform basis meant that we didn't see caller ID for about 10 years in the US. It was delayed because they had to reconfigure the interface to support multiple parties of players. And that loss of welfare we'll never get back because it just doesn't come there. And so that's the assumption that we can just make everything a third-party open platform ignores the history of regulation, but also theoretically, it's simply not true that you can force everything to be. I'm sitting in a hotel right now. Could we have open access competition for the maid service, or for the swimming pool service, or something else? The answer is there's things that have to be done on an integrated basis. Two other quick observations. We don't have a lot of data on the impact of the DMA because it's too new. We do have some impact in some other areas. European privacy regulation, the General Data Protection Regulation, GDPR, has been around since 2018, and it's pretty clearly had a negative impact on innovation, venture capital investment, and small and medium-sized enterprises because it's very hard for them to comply. China is also done something, it's not really DMA-like, but cracked down on the digital platforms. Venture capital investment is down across the board. And this is not a surprise. For the same, you make something more expensive to do, you get less of it. And so this is a real thing that we have to think of as a trade-off. There's an optimal amount of regulation we should think about doing. Regulating more always increases costs, but may only marginally increase the benefits. So when you look at the EU, they've got GDPR, and then the DMA, and then the AI Act, and then the Data Act, and then the Data Governance Act stacked on top of each other, and the Digital Services Act. The answer is, at some point, there's a question of whether the additional burdens are actually creating enough benefits to justify them. And that's a difficult question, which we all have the benefit of watching and studying in the years to come.
Thank you, Christopher. I'll move to a question that I have now that I would like you to comment. You have a strong argument against ex-ante regulation deriving from not only the ambiguity of vertical conducts, but because of the fact that in vertical conduct, there is the factor of innovation and benefits and efficiency to the consumer. And regarding innovation, you have mentioned the difficulties regarding Copilot, for instance. And that's a field where you integrate the AI technology with software services like the Office package. And there are already some concerns raised by foreign antitrust authorities about tendency of concentration in the markets for AI. Although, if you take a look, there are quite different characteristics in the AI markets and digital markets. For instance, it's not clear where are the network effects in AI markets. There is no zero marginal cost as in digital markets. So there are questions regarding, although there is this joint statement also by these antitrust authorities. And I would like actually to comment, since innovation may be a problem for ex-ante regulation, what about the impacts of AI market? If we cannot assume that the AI markets are going to be concentrated, what may be the impacts of the dynamics of competition in AI markets within the dynamics of competition in digital markets?
So it's kind of, maybe I say this sometimes, I know regulators are often concerned about AI and it's, everyone's obsessed with AI. I've never seen anything that has caused the entire university community to lose its mind simultaneously, like ChatGPT's launch a little over a year ago. On the other hand, what do we see? We see companies pouring money into innovation, investing heavily into doing this in exactly the kind of race for success that we're trying to encourage. This is a race to the top. And it's incredibly exciting. We know very little about what the successful business models are going to be. You can sign up for ChatGPT 4 for $20 a month or get ChatGPT 3 for free. I can't believe that they're losing money. I mean, there's no way that that's the business model that we know we're going to implement. And so trying to figure out how this is going to look seems really, really incredibly difficult to do. And so what's interesting to me is we also have to understand the origins of AI and how you train it. It requires training data, but it requires training data at such a scale that it's really only publicly available data scraped off the internet. And so this is going to change the nature of competition. So it's unlike search, where the concern is always, oh, the best source of information is prior search results, so the incumbent has an inherent advantage. Anyone can scrape the internet. And so what you're seeing here is all these are based, we know, what we know, ChatGPT 2 was trained on Reddit data, ChatGPT 3 was trained on Wikipedia data, and ChatGPT 4 was trained on we don't know exactly what, they haven't said. But in general, we know that the corpus has to be very large. And the advantage of being an incumbent, if that's the real basis, may be dramatically different. And you see in a world where now, this showed up in the Google case, the search case that's going on now, if we shift from generating search answers to search queries from previous search results to AI, the barrier of entry created by these past data fundamentally changes. And what increasingly we're seeing is some people are not searching in Copilot or Google at all, they're going directly to ChatGPT and AI. In which case it's not a change in the input, it's an actual substitution effect for search in ways that are radically different. So what we're seeing here is huge differences. And what I would say is, in the concern about integration with Office, to me, the Google example with Maps is a good example to me of how, and what we learned from vertical integration, is that combinations of functions on a vertically integrated basis can lead to extremely big innovations. In fact, I always think of Clayton Christensen, the late Harvard Business School scholar. He actually thinks that innovation in this day and age is no longer like new technologies you can patent. It's business model innovation. It's combining elements in different ways that no one else has done before. And that, in fact, I always think of Apple. It always baffles me. My students love Apple. I look at my computers, their desks, they're all on Apple, even though they're like 3 times more expensive. And part of it is they vertically integrate everything they do to create this seamless user experience that, if you pick up someone else's iPhone, you know exactly what's going on and the compatibility issues, and that has value. And I often say when I talk to people, in fact, I love the world in which we have one vertically integrated platform, which is Apple, and another one that's open source and open all comers, which is Android. We're better off as consumers having, instead of both of one or both of the other, having a variety of strategies. And from a business standpoint, it makes sense. If your opponent's closed and you're the number 2, you go in open. If the opponent's open, you go in closed. I mean, why would you do the same strategy unless you can do it better? And so I see tremendous value in the Apple approach, to where I would say, should we say no one should do that and that there should not be able to do that? I think that's a problem. Now, the idea that the Apple approach automatically leads to harm is also wrong. Apple tried to force us all to use Apple Maps. They failed. Google tried to launch Google Plus and kill off Facebook. They failed. Google tried 5 times to do social media, and I can give you other examples too. What we learned is there's nothing magic about the big platform. They have to combine things in ways that create value. Now, the last couple points I'll make is, in addition, we have to bear in mind that remedies such as opening things up don't always work. So what's fascinating to me is we can go back to the Microsoft case. We opened up the operating system to every browser and made Microsoft sell a version of the operating system that didn't have a browser. The demand for that for over a decade was exactly 0. Not virtually, like literally nobody bought the product. And so the funny thing is we have to think about, we can enforce these remedies, but if there's real value, people change. So for example, Windows, Microsoft ships Windows with Bing as the search engine set apart, because they're vertically integrating their search with their operating system. 95% of consumers change it. And in fact, they're giving choice screens to people in Europe, and everyone's still choosing Google. Now, what does that tell us? It's probably they're choosing it because they like it better. It's doing them, providing better service. And what you start to see then is benefits in these worlds where we can create even opportunities. It doesn't always work out. For example, in data portability, the open banking rules in the UK are in place. If that's a place where the data is already pretty similar, no one's actually using it, and they're actually extremely frustrated with it. And so it's quite interesting. The last point I would make is that we have to bear in mind the whole notion of ex-ante regulation requires you to get government permission. It really hurts permissionless innovation. And if you're going to do an innovation that's inconsistent with the way people thought about it before, you essentially have to request permission. And so Angela Merkel quoted the Prussian motto once to represent the difference in innovation between Europe and the US. In Europe, in Germany, everything that's not permitted is forbidden. In the US, everything that's not forbidden is permitted. And to me, that if you want a pro-innovation approach, let people try crazy stuff. Have ex post regulations step in after the fact to stop any problems that emerge. But what we don't want is people to have to go to a government official and convince them that this is a good thing before they can try something new. Because frankly, most of the stuff is terrible, and we don't know in advance which it is which. We just got to try new things and see what goes. Because I can give you any litany of things, whether it's Google or Federal Express, of all these great businesses where people said, Harvard Business School professors gave them Fs because they said that will never work, and now they're billionaires. And so I mean, it's just we're just not smart enough to know in advance what we need to do ex-ante regulation in something as dynamic as AI.
Cesar and Bianca, do you have any questions?
Bianca first.
Sure. As you said, ECHO is almost dead in the States, but we have been seeing a lot of judicial decisions against big techs recently. On the other hand, recent developments have significantly altered the status of the Chevron doctrine, a principle that has always shaped U.S. administrative law for decades. And we see recently, like last week, for example, we have seen an editorial in Washington Post. Washington is rightly ripping up Silicon Valley's carte blanche, and in both San Francisco and Washington, a sense of mutual anonymity and suspicion is growing. So when you propose a greater emphasis on economic analysis based on specific case evidence rather than applying rigid rules, because more flexible approach will allow antitrust authorities to tailor their intervention. In this context, how countries can update antitrust laws to reflect modern economic realities, such as the rise of digital platforms and new forms of market power, and how this can shape the justice understandings, because we can move. We don't have an ex-ante regulation, but if we have a populist mentality, even the judicial approach will have the same result. That's the same.
So it's interesting your perspective, watching from the outside. I guess I would say, yes, ICO is dead. We agree there. I'm not sure I agree with some of the other characterizations. So Chevron is dead, but Chevron never affected competition law in the U.S. because we have a judicial enforcement system, and the agencies don't get deference. They bear the burden of proof, so it's unlikely to change things very much. When I look at mentioned the cases, the judgments, in general, the enforcement officials are losing most of their cases. The only exception being recently is the Google case. That's sort of the big one that's changed it. Most of the others have gone against the agencies. And what's interesting about the Google case to me is, you mentioned the Washington Post editorial. There's also a Wall Street Journal editorial that captured my gut reaction. I have to admit, I've been on the road. I haven't read all 286 pages of the judgment yet, of the opinion yet. But the opinion says Google's really efficient. They're investing. They're doing all, and consumers really like them. And the funny thing is, and they're saying, so what's the problem? And so in some level, generally we say, unless we have to point at there's something they're doing wrong. And if what they're doing wrong is outcompeting their rivals, then that's not a bad thing. The other weird thing about the case is the rival they're outcompeting is one of the only companies that's actually as big as they are in market cap and don't really need government's help, which is Microsoft. And so there's a deep irony to me in that case. And there's a lot of people who think that there's some parts of reading the opinion, it does all these good things, and they haven't really found the anti-competitive conduct hook that they're talking about. I can see certain kinds of contractual provisions becoming problematic. But if the reason they're so big is that they're doing it better than everyone else, then penalizing for that is not consistent with traditional antitrust law. Now, you mentioned, changing. To me, this is adhering, not changing to a new approach of what I'm proposing. It's actually adhering to traditional antitrust law. Rule of reason is our default. And that, in fact, we have shifted over the years to an effects-based analysis, which is still very consistent. And what we see is the governments in Europe and the US able to litigate cases and get them to judgments and sometimes win. And in fact, I think that's a really important point. It does bother me when I see the EU, you look at, in the Google shopping case, its impact on Google's competitors. When I want to know what the impact on consumers are, I want to know if total transactions went up. Are people buying more? Because that being the best indicator of what's going on. Do we need better understandings within the antitrust enforcement officials? Yes. We need to understand network effects better. We need to understand data better. For example, one of the articles I'm writing for the Antitrust Law Journal right now is people just talk about data as if it's a unified phenomenon. There's different types of data. There's structured and unstructured data that feed models in different ways. There's data is very not in terms of its size, but in terms of its variety, its quality. And we're seeing in a world now where AI is being trained on smaller amounts of higher quality data. We need to understand the competitive impact. If we just look at big data, it's a term I dislike a lot because it encourages us to lump all types of data together. We'll miss something important without understanding the data science, because there may be small amounts of data which you can only access through certain means, may be an enormous problem. So we need to think about this motivated by business models, not just labels like big data, or another one, I don't like big tech, I don't like GAFA, because it encourages us to take very different companies and lump them together and treat them the same. I think they're skipping the hard work of what we have to do, which is case-by-case analysis to understand what the impact of consumers is likely to be.
Professor, I think everything you said is quite persuasive. The problem, but perhaps the problem is even worse. I have we got a debate some time ago here in Brazil, and a friend of mine called me the attention that perhaps the Digital Markets Act had made a choice on this trade-off of competition and innovation. It would be an implicit trade-off. They just said, well, it's so per se, self-preferencing, all of this content is so per se, that they would say, we just don't care about incumbent innovation. We just care about entrant innovation. So in some sense, it's like the DMA has chosen not to consider any innovation from the incumbents at all, to just say it just doesn't matter. I just care about one sort of innovation from entrants. And so we could perhaps rephrase your trade-off, competition and innovation. Competition in digital markets is innovation in some sense. It's just innovation. So in some sense, it's just there's a trade-off in innovation among entrants, innovation between incumbent and entrants for everybody. So they just disregard this second source of competition and just focus on the first origin of innovation. So in this sense, for me, it's much worse than you're talking about. Is that true, or in some sense they care about incumbent innovation? Because I really in doubt about it.
So you're actually putting it in a relatively flattering way towards the Europeans. Now, this may be a very American comment, but the other way to frame it is not so much an incumbent versus new innovation, it's trade protectionism, which is they don't have any incumbents, so why do they care about that? They're trying to give a leg up to their companies, and so they can slant it that way, and there's some evidence in the way it came about to support that. Okay, let's take but set that to a side. Let's try to take your suggestion at its face and assume that they're motivated by good things. First is, it's not clear to me that that you have a better source, that we think that incumbents are never a good source of innovation and entrants always are. So the example I'll give you that I always think about is Google Android. So Google Android is often, now there's a big antitrust case that's going to the European Court of Justice. They lost at the initial levels against Google. Now we have to bear in mind, what I think about this, Google, when they bought Android was a company with fewer than 10 employees who had no revenue, and their ambition was to make an operating system for digital cameras. And so the question is, why did they become great? The answer is possibly because they were combined with Google's resources and their ability, they turned them into something. But the real measure to me is what Samsung and Huawei are doing. So they're big phone manufacturers. They're uncomfortable that they have to partner with Google so closely. They would love to have more than one source. And so they have attempted to do what Google did. They've gone back to the Linux source code and tried to develop their own operating system. As you may know, Amazon did this with Fire OS, did it just for readers, but they've done it. So Samsung was working on this product called Tizen for many years. Huawei's been working on Harmony. They've both failed. And we could say that's because the companies are not well funded or they're technically incompetent. I don't believe either one of those statements. I think these are very good companies. What they're telling us is that Google has managed to accomplish something technically that other very well funded technical companies have tried to do and failed. In which case, what we're seeing is the incumbent Google is an important source of innovation. The other example I always give my students is Qualcomm, a company other people love to hate. In the mid-2000s, they had a proposal to make internet phones work better. Everyone said, great idea, it'll never work. Be a huge benefit, it'll never work. They made what everyone else thought was impossible work. So guess what? They make a lot of money. Apple is very uncomfortable dealing with Google, so they partner with Intel to try to create a rival chip so they don't have to buy from Qualcomm anymore. And what happens? Apple and Intel fail. Apple is a much larger company than Qualcomm. You can't, by several orders of magnitude. And yet, and Intel's one of the best chip companies in the world. Between the two of them, they couldn't do it. And in that sense, you have to ask yourself, is Qualcomm's success you could say it's from anti-competitive conduct, and we have cases about that, but some part of it is because they're able to do technical innovation, they happen to be the incumbent, that other people have attempted to match and have not been able to do so. And so if you see a world in which this happens, why we should inherently favor new entrant innovation over incumbent innovation as a matter would depend on an assumption that a new entrant is always better. By the way, in biotech, we see incubators which create new technologies and then sell them. Why? Because sometimes the inventor's not very good commercializers, but you see that sort of dynamic, and it may be sector specific. We may not see one solution that applies more generally, and we may see things that vary greatly. The one other thought I'll leave you with, and this isn't directly speaking about what you're saying, I was thinking about Bianca's question about why don't they roll that out all over the world? The answer is they're businesses. They have to look at the return and what they can do and the compliance costs. And we always think the problem with compliance costs, we can always ask companies to do more, but we have to ask, is it worth the benefit? I keep thinking of GDPR. They now make us, we have to affirmatively opt into consent. So they had to create new things where we now have to opt in. We now click accept a lot more, but it appears to have had no material impact on anyone's beneficial to their privacy. And it's a compliance cost that doesn't appear to be creating new benefits. There is a particular form, like under privacy law, you can ask the University of Pennsylvania hospital, who have you given my data to? If you ask people, should they have that right, I think 99% of the people will say yes. That right's been asserted fewer than 10 times in 20 years. And you have to do training and tracking and auditing and all these other things. And the answer is, you can always ask people to do more compliance, but whether it actually creates benefits is a tough question. And that's the interesting question to me with the ex-ante regulation sitting here. And you may see, and the thing that many countries I talk to are worried about, it's not that the innovation will stop, they'll just bypass their country. If there's an individual country's law that becomes too difficult, they'll look at it and they'll say, it's just not worth selling this country. And the problem is you end up being left behind. And so finding out that right era to discipline companies when the risks actually happen, because we do have to do that, but enable an environment where innovations that aren't harmful can flourish and people don't bypass your country, I think is really a difficult problem we're all trying to thread, but I think it's one that it's important for us to think about more and more.
Christopher, there are some questions from the audience in relating data protection with competition, AI regulation with competition, and human rights protection with competition, bringing some trade-offs. So I'll try to pack in two questions. The first one is, you have said that data protection regulation has hindered innovation and economic development in Europe. Do you think that the regulation and standards of governance of responsible AI may have the same effect? This is the first question. And the second one is, shouldn't there be a balance? That is, shouldn't we sacrifice competition in the name of protecting human rights in the digital environment?
So what I would say, let's take them one at a time. So I do think GDPR has had a negative impact. And if the EU understood that with their eyes open, I would understand the trade-off. Sometimes you make that trade-off. Data protection, it's like, we have free speech. We don't ask about whether free speech is going to maximize competition. It's a civil right, it's a human right we protect. If you read the economic impact statement that the Europe issued at the same time as GDPR, though, they said that this will actually not increase costs, it will lower costs because harmonization will reduce the cost of doing business across Europe. And so they didn't assume, their study says we don't have to confront the trade-off between costs and protecting rights because it'll actually reduce costs. They were wrong. And it's unfortunate they made the decision. If they knew what the real costs were and said, okay, I understand, it's worth it to us as a society, that is their decision to make. That's not how they approached it. And my concern with AI is that also had a very strange political dynamic around it. So they began and were working for years on a risk-based system, which was we are going to assess the risks in certain sectors, in criminal law and healthcare and all these different areas, because the risks are very different, and we will regulate a higher level on the higher risk areas and a lower level on the lower risk areas. I think this is completely coherent. It's a shift from looking at inputs, like, what do you do with the data, and actually trying to say, well, what are you doing with the data, and what the effect is going to be. And one of my favorite examples, the first use of AI by the US government was handwriting recognition by the US Postal Service. I think this is a wonderful use. It's going to reduce costs and get mailed a little bit faster, and the risks associated with misidentifying this is fairly low. And so what we see is a heterogeneity that's inconsistent with the risk-based approach taken by the EU initially. But then last fall, as Spain was about to leave the presidency of the EU, they saw ChatGPT happen, and they had to do something. So they've taken a risk-based approach, which is coherent, and added on top of it a problem with a new approach of what they call general purpose AI with systemic risk. And they're saying we're going to regulate them heavier. What determines whether it's a general purpose AI with systemic risk? The number of calculations needed to train the AI. So now we've gone again from risk-based back to inputs in ways that are not technology neutral, and assuming that the risks are going to be based on calculations and we don't have to look at whether it's done for the Postal Service or for healthcare or for something else. And in addition, they give a free pass to open source software for reasons that it's not entirely clear to me that open source is less risky. It has different risks, but we haven't really studied it. And it was more, again, a political move. But the idea that they're already having regrets in Europe, they actually think they got the thresholds wrong. I always said they're training AI on lower amounts of data and fewer calculations. They actually thought they're only going to catch about a handful of companies. They're apparently going to catch hundreds. And as you see the dynamics, France, Germany, Italy, and Austria opposed the AI Act and held it up because they were worried about protecting their own domestic companies. And so they created exceptions that took out Mistral and Aleph Alpha and all the pet projects one at a time. To me, this is a terrible way to make law. I mean, it's just unfortunate. But what we're going to see is our ability, what I said about concerns about digital platforms and ex-ante regulation apply even more strongly to AI. I mean, we don't even know what this stuff is good for yet. And my favorite quote is there's a person I work with who does healthcare AI. When he's asked what's his biggest fear about AI 10 years from now, his biggest fear is we won't use it enough. That there'll be huge healthcare benefits and the ability to deliver in remote areas and all these other things that could potentially really change people's lives. And that's a difficulty. Now, on the balance with human rights, this is a problem we always face. In terms of economics is about social welfare, thinking about people as a whole. And it's the difference between that and individual rights, which is like Kant, which is there are things that we don't let people sell themselves into slavery. We don't ask whether it'd be good for society. It's just there's certain things we don't allow people to do. And there has to be a dialogue between those two to make them understood. And we have to find a balance, and that is ultimately a political choice. The interesting thing that we see is, in terms of data protection, is the surveys in the US suggest that people have different senses of data protection for employment and healthcare, financial services and education and the like. And that, I remember the enforcement official who worked for the communications regulator during the short time they were in charge of doing it said with great pride, well, we're catching people for privacy violations for disclosing telephone numbers because machine identifiers are considered US has a phone book and I'm listed publicly available to this is not, I don't consider this sensitive information. In fact, I want people to be able to reach me. And that's a good example where I don't have the same sensibility. The problem with European data protection regulation is it applies the same standard to all personal information without any context whatsoever. And so it'll apply its personal information to like my phone book example where I want it to be public. I have the same problems about something I would consider to be extremely sensitive, say my healthcare information. And the US approach tends to be more sector-oriented and tends to be calibrated more towards risk in ways that what we find is that it can create benefits. So let me give you another very simple example. In the San Francisco area, some cities are imposing data data protection regulation, requiring financial services companies, when they collect data, to only do it on an opt-in instead of an opt-out basis. That is, they cannot collect it unless the individual applicant says, you can use my data. They can't say, I can use it unless you object. And that means the total amount of data they get is going down. Empirical studies have looked at this and said, guess what's happening? Mortgage prices are going up in San Francisco. Why? There's less data available, and the lending companies are less able to figure out which potential lenders, what borrowers are higher risk and which ones are lower risk. So you used to be able to tell them apart by the data and charge them different interest rates. Instead, without that, they have to include a risk premium on everybody. And that includes the people who are good risks, who used to be able to signal that in the past, and it's now more costly, and they used to be able to work that out. And that's going to apply not just to people who opt in or don't opt out, but every other person in the market is now seeing higher prices. And so what you're seeing is a social impact done in the name of an individual right. And we have to ask ourselves, is this effective in protecting actual rights? And at some point, you have to trade off between the two. I think about this in terms of, the old line, we want 1 million people to go free instead of putting one innocent person in jail. Well, if we mean that, we can't have a criminal justice system. The answer is if we're going to make mistakes. Nothing is perfect. And the other example I always think of these days is COVID, which is quarantines. In quarantines, we invade someone's human rights. We keep them from moving around in the name of public health. And so the point I would make is, yes, that's a concern. We don't want to do that very often, and we want to be very careful about when we do it. But there should be a heuristic, a rationale, a framework for saying, but when the harm to society is so great, or the benefit to society is so great, there are times that we may need to trade off human rights, that is, individual movement, and make you stay in quarantine, because the benefits of society are so great. And we need to have that conversation. And I think different societies may choose to draw that line in different places.
Professor.
Bianca, may I make one last comment? Well, I think it's very interesting, your analysis regarding the regulation of AI, where the risk-based approach is suitable for the results of applications in terms of risks and impact. And when regulating general purpose AI and generative AI, there was a move to processes and not on results of applications. And the same was incorporated in the Brazilian draft bill for the regulation of AI. That is the European solution was transplanted. And there has been positions in Europe by saying that with these restrictions, for instance, you will have opportunities for the development of natural language processing systems or generative AI within Latin languages or European languages. So that's being seen as an opportunity for investment and innovation in Europe. But what we see, for instance, another transplantation, it was the questioning in Europe of the development of Meta AI assistant using data from social networks. So the same initiative occurred here with the Brazilian Data Protection Authority. And of course, this is a problem for innovation, but the focus was in process. Although the results of natural language or foundational natural language models are by their very characteristics anonymously for general language generation, the focus on the processes, say, if you collect and store personal data, although these personality aspects are not reflected in the result, there is a problem on data protection law. So it's the same focus on processes and not on results. I just would like to hear you a little bit more about it.
Okay. So the first example you gave is about Spanish language. What's really interesting is the OpenAI is partnering with Iceland. I don't know if you've seen this, which is they want to, Iceland is a bigger problem. There are 370,000 people in Iceland, and they're worried their language is going to die. And so the question is, it turns out OpenAI, ChatGPT is very good at Icelandic, apparently, and they're trying to do things. And so it's interesting. Some people are trying to create barriers around their countries to protect their own, to develop their own language. It may lose some benefits as well. I mean, there's some ability to go outside, and trying to figure out the balance to do this is very tough. Although how you stop people from using language is very strange to me. I mean, I don't know how you can do that. Now, what you're talking about, when you're looking at the process-based approach, I've got several concerns. One is it almost begs for obsolescence, because you're based on an understanding of the processes that AI is doing today. Well, one, I will say most regulators and legislators and even enforcement officials don't have a great grasp on how AI is actually being done today. Second, even if they had a perfect grasp on how it's being done today, the chance of it being the same way next week or next month or next year is zero. And so the problem is, process-based things in law, it takes time to change. The choke points on legal change are different than market-based. They're not decentralized as people lobbying and different interests that are represented. We all know that, for example, startups without revenue tend to be underrepresented in lobbying processes because they have no money. And so we see there's certain biases that we can, and at a minimum, it's going to take 6 months because you have to publish the rule, you get comments, all the other process you got to respect. And so there's a tough question about whether that's the right way to do it in terms of just the mechanics of doing it and keeping up. But the other problem I've got is any process-based approach is inherently incomplete and misunderstands AI. So what AI happens is, like any complex system, it has emergent qualities that only appear when it's deployed at scale, that you can't study by looking at the inputs. And there's weird things that happen which you don't anticipate. When we know that this is the nature of complex systems generally and AI in particular. And particularly when you have a world where different actors are doing different things at different times, I always think of, it's not quite AI, it's flash crashes in stock markets. Someone says, if the price hits here, sell. And what happens is you look at each one of those orders, it makes complete sense, but the market drops, so this person sells. And it drops the price, and it causes that other order that said when it hit that, it sells. And you get a cascade of these orders that cause the stock price to drop like this, and then they go back up. Could we have analyzed it and seen it coming? Well, unless we see every option trade and compare it under every permutation, the answer is no. And this is the inherent nature of these sort of systems things. And so we have to understand, we don't really understand them until we see them after the fact. And so shifting, that's what I like about the risk-based analysis and looking at outcomes. I actually think even if you're going to do a process-based component as part of it, you have to do the other part, because you won't understand AI as a phenomenon in other ways, particularly, by the way, if you want to think about hostile actors. Because that's what engineers are terrible at anticipating bad actors. They are very idealistic. They imagine everyone using it for good in the way it's intended, and we know that's not the way the world is. And so we end up having very strange things that happen when the trolls start getting a hold of your AI. And it's something that we need to learn from and make sure that we don't just look at the inputs that go in, but actually make sure we at least evaluate the outputs in some way.
Great, thank you, Christopher.
We have a last question from the audience, Professor. A question from the public mentions Anu Bradford's work on the false choice between regulation and innovation, and would like your comments on this. And also, he would like to know what you have to say about Kindle acquisitions and the FTC's work to curb this in the US.
So, two points. Regulation does not always hurt innovation, because sometimes regulation can enable innovation and can be positive. But well-designed regulation can help, but badly designed regulation can hurt. And so the point I would say is, on a New Bradford's point, it's not really, in some ways, it's lumping all forms of regulation and asking, does it help or it hurt? I think that's the wrong question. I mean, heuristics like the ex-ante example I gave you is a useful framework to think about when imposing, command and control regulation or, requiring permission is more likely to be beneficial to innovation when it's not. I would say that compliance with standards can be essential so that interoperable components work together, or we understand safety standards that are made, or if you're selling things into a market, people know what they're buying. It makes certain standards. That can be quite positive. But we should never forget always, there's also a tendency, and I see this reflected in Europe, of, well, if some regulation is good, more must be better. The answer is we have to think about optimality. Compliance is costly. Regulation is costly. And we think about this in law sometimes about enforcement and disputes. Really, most of the way we experience law is trying to avoid disputes by actually conforming our behavior in advance to what we're supposed to do. And you give me a bunch of rules in advance. The more rules you give me in advance, the more I'll have to spend. And so you see this as a fundamental tension here that I think we need to think about as an optimal amount of regulation, because frankly, I think GDPR is filled with things that create a lot of costs that look good from a rights-based standpoint that actually aren't really benefiting consumers and are simply hurting innovation by limiting the ability to combine data, or report data, or use data in ways. AI is the perfect example. We're using data in ways that no one authorized and no one imagined, and we're combining them in enormous ways that are creating potential benefits. And is that always okay? No. But the position that it's always not okay, I think you may lose a great deal. What we need to have is a more nuanced, more granular approach that actually puts consumers first instead of protecting data for its own sake and by looking at it. Killer acquisitions. The Google Android case is a great example of people think it's a killer acquisition. You need to understand, though, that we have to be able to, the problem with new companies, they think about their decision. I'm going to invest in this new technology. There's, say, 3 outcomes. I fail, I succeed greatly, and I do an initial public offering, and I go public, and I make a lot of money. Or the intermediate case is failing that. I do okay, I don't fail, but I don't do big enough to sell to issue my own stock. I sell out to another company. Okay? So the problem you have here is if you block killer acquisitions, you've taken exit path 3 off the table, or risk doing that, or for at least some of us. In which case, when I do the expected value calculation, I have a 80%, 90% chance of failure, so that's 0. I have a 1% chance of IPO, which gives me $10 billion, and I have a 9% chance of selling to a company, and we say that that's going to happen for $100 million. And I take that 9% of $100 million off the table of my ex-ante expected value calculation, and all of a sudden, I have to now compare a smaller number to my costs and decide what I'm going to do. Okay? So this is the concern I have. Now, if we had the means to separate the acquisitions that were going to turn into competitors from, to determine which companies are going to turn into competitors and which ones are simply better integrated into another company, and we could do something like the exclusionary conduct element that's being eliminated by the DMA, or the things we have in all antitrust law to separate the two, that would be great. The problem is we don't have that tool to know which of these startups are going to be rivals to the big platforms in the future, and which ones are going to fail, and which ones are simply going to be better acquisition targets, or may depend on integration with larger systems in order to deliver value. And so we need better fit with the understanding of the acquisition phenomenon and tools in legal elements that we can add in that will help us make sure that we don't reduce value of innovation, but actually at the same time can protect consumers better.
Great, Professor. We are approaching more than 1 hour and 20 minutes of live, so we have finished right now. It was great insight, many things for us to think, and would also love to have you back with us, because this matter in Brazil is really still evolving, and it's a matter of great discussion in our government and in the Congress, etc. So I would like to thank you very much for your participation with us. And I'm gonna finish in Portuguese right now to our public. Thank you very much. Bom dia, pessoal. Nos despedimos então, lembrando que o nosso Núcleo de Mercados Digitais tem uma página exclusiva no site do Legal Grounds, onde vocês podem sempre acessar todo o nosso conteúdo que discutimos tanto hoje quanto em todas as outras nossas lives sobre regulação dos mercados digitais, que vão fazer praticamente 2 anos agora em outubro. Além dessas gravações dos webinars anteriores, leituras recomendadas, artigos e muito mais. É um espaço que nós criamos com muito cuidado para ajudar pesquisadores, estudantes, formuladores de políticas públicas, membros do governo, do mercado e todos que se interessarem por esses temas tão importantes para uma regulação ainda em desenvolvimento no nosso país. Mais uma vez, nosso muito obrigado por estarem aqui. Esperamos vê-los vocês novamente nos nossos próximos webinars. Bom dia.
Christopher, shall we meet in 10 minutes in the lobby? I believe in 15 minutes in the lobby, it's enough for us
Okay.
to go to the ministry, ok? César, encontramos você lá, tá?